Hi, everyone. My name is Tereposky. I am an employment lawyer with the firm of Samfiru, Tumarkin, and I am located in Calgary, Alberta. I'm here today to answer any questions that come in about employment law, about your rights in the workplace, and hopefully we have a good discussion here today and answer everyone's questions. If you are joining us and you have some questions, just be sure to get them up in the chat as soon as you can so that we do get to that question before the end of the session, which is only about 30 minutes today. So while we're waiting, I can just raise some sort of current event issues that we can think about. So there's been some, you may have heard, there's been some layoffs by the Meta group that affects employees at Instagram and WhatsApp, and they're kind of cutting back their staff. So it's not a situation where the employees are being let go for performance issues or anything like that. They're just making some cuts. So in that situation, employees, should be looking for severance packages. They should be entitled to a full severance and should be getting, their offers, if they're getting them, off to employment lawyers to discuss and to review to make sure that they are getting their full entitlements. Often, obviously, when a company is doing a lot of layoffs, they're trying to save money. So those first offers that come out, if they are making offers, may be below what what the entitlements of the employees are. So it's just good practice and prudent of employees to go and get that reviewed by an employment lawyer to make sure their rights are being upheld. So it looks like we already have a question. It's from STBean2. And the question is, my employer suspended me over concerns about off-duty conduct. The police are involved. It's an odd situation, but I expect to be cleared. Can they let me go for cause because of this? Well, it's a super interesting topic, actually. That's been something that's been in kind of the employment sphere for the last few years, and a lot of that has been caused by social media. So there's been some instances of employees who are doing things that maybe aren't what the employer likes on social media, and that's been taken into account for whether that can be cause for termination. What the courts have said basically is if the off-duty conduct has an effect on the employer or has a connection to your employment, that there may be cause for termination. So in the social media case, if you're making posts on social media in a way that doesn't connect you to your employer, that you're an anonymous person, but they know it's you, it's pretty tough for the employer to say, well, this is it casts a bad light on me as an employer, and I'm gonna have to terminate you for cause. But one example in the case law is I think it was a firefighter who, had his job and he was in uniform in his social media picture and was making posts that, were sort of thought to be detrimental to the employer's interests. And I believe that was held to be a termination for cause. So in your situation, the person that asked the question here, I think it depends a lot on what that off-duty conduct is. Whether it casts a negative light on the employer. Now, if the police are involved, as you've indicated, there can be cause for termination in the case of some sort of illegal activity, because it may impact the trust in the employment relationship if you're convicted of a crime, right? But it's very fact specific. It'll depend on the severity of the incident, depend on the evidence involved. They really should be doing an investigation into what occurred. And so it could take some time for them to get to the point where they really have enough to be able to terminate for cause. So yeah, very fact specific. I would say that, if you're really concerned about it and it gets to the point where you are worried that there's going to be a with cause termination, to, contact us, and, we can go over all the facts with you, because it's not a sort of yes and no question. It's one of those that depend on the severity of the incident. So to find us, obviously you can find us on our website, which is just employmentlawyer.ca, and there's many of us depending on where you are and what you're closest to. Obviously I'm in Alberta, so if you're in Alberta, look us up and reach out, and we can have a conversation about that. I have another question from YouTube. And the question is, what if you don't trust the person or persons that you need to address a complaint to, especially if you've witnessed them not protecting a team member for something of the same situation that you're in? So I'm going to assume, because, kind of have to read into what the details are here, that this is maybe some sort of a harassment situation or something like that. And employers should have channels where you can, if you're supposed to report to your supervisor in that case, but your supervisor is the one harassing you, obviously that's not going to work. So the employer should have an alternative. A lot of employers, and depending on the size of your employer, some of them have, an online sort of way that you can make complaints in like an intranet or something like that. So maybe check to see if something like that exists. And yeah, if you don't trust the person that you're supposed to complain to, you may be able to find somebody else to raise that with. As long as it's somebody in management, really the employer is obligated to look into a complaint if it's a harassment situation. But yeah, I understand that that's seriously quite a dilemma when, either it's, someone you don't trust, or it's the actual harasser. It's the person that you're complaining about. Obviously, that's a very difficult situation. And if the reason that you don't trust them, which is what you're saying, that you've seen them not protecting a team member, then, you may have to go over their head. And talk to kind of their supervisor if that's something that's available to you. But like I said, I would check into whether or not there is some sort of online option for making a complaint, because a lot of employers do have that. I have another question from Pedro. It says, if a coworker retaliates against you and you have proof of it, and your boss wrongfully terminates you, do I have a case? Can I take him to court directly? Okay, so can I take him to court directly? I'm not sure who exactly him is, but I'm going to assume that that's your employer, because in an employment situation, you can't take a fellow coworker to court. And I'm not sure if that's what we're trying to say here, but all employer situations, you have to get your recourse from the employer. Employees are generally protected if it's in the context of employment. So you would have to make a case against your employer. If a coworker retaliates against you and you have proof of it and your boss wrongfully terminates you. So if you're being terminated in connection with a retaliation by your employer, that is a violation of the Employment Standards Code. And it could also be a violation of human rights legislation, depending on whether it's a discriminatory action in play. And do I have a case? I mean, it is very difficult to see whether you have a case without knowing all the facts. But it is something that, I definitely would want to know a few more details about what the retaliation is, what the proof is, and, how the termination works. Generally, I mean, if you're terminated, unless it is a for-cause termination, you're entitled to severance. So even if you are terminated in this scenario, it's doubtful that it doesn't sound like there's anything that could be alleged as cause. So, you are entitled to a full severance. So if this does happen, you're going to need to look into, what your severance should be and whether or not your rights are being respected. And that's really your remedy. So I hope that answers that. Without some more detail on that one, it is a little bit difficult to get into whether you have a case. But, if there is a retaliation against you by your employer in relation to a complaint about safety, a complaint about not having your employment rights respected, a complaint about something that might fall under the Human Rights Act, discriminatory actions, then it is illegal. So you may have an action even with a tribunal or with employment standards in addition to court. So I hope that answers that question. There's another question that's come in from Mr. Gray. It says, my partner is being told her position is no longer available after finishing maternity leave. We think they just replaced her while she was off and don't want to bring her back. What can she do? Okay, so under the Employment Standards Act code in Alberta, if you go on a maternity leave, the employer is obligated to bring you back to work in the same position or something comparable. So it sounds to me that if they're not bringing her back in the same position or something comparable, that they're in violation of the Employment Standards Code. So I would, that's your first option, is to look at that employment standards piece. And, if there's been a breach, we can take action under the employment standards branch and make an employment standards complaint. If she's not being brought back and they are offering her a severance package to not come back, then, the next step is to make sure that severance package is appropriate. Not only is there a consideration here of how much notice, if it was a lawful termination, how much notice should be given, but there may be an entitlement to something beyond that because of the fact that there has been likely a breach of the Employment Standards Code by not bringing the employee back after maternity leave. So I guess, what can she do? She can reach out to us. We can try to advise her of next steps. There could be potential to negotiate a better severance package by pushing that piece that there's likely been a breach of the Employment Standards Code. There's a possibility of making an employment standards complaint, and we can help with that as well. So there's a few options. There may also be a human rights violation in there. So that might be another venue that we could help you with. So there's a few options of what can be done there. Obviously, if the employer doesn't want to bring her back and they don't, you can't force them to bring you back to work. But, what's your recourse if that was an illegal decision that they've made by replacing her and not offering her job back when she returned from maternity leave? So there's a few options for what to do with that situation. Like I said, reach out to us and we can talk about those in more detail. But in general, I think those are kind of the three areas to look at: is a violation of the Employment Standards Code, human rights violation potentially, and then just severance, pay in lieu of notice that should have been given at termination if she is not brought back. Another question from Sam. Okay, I think that's just a comment, so that's not a question. I won't go there. So this is Pedro again saying, my coworker had my boss put me on a performance plan only to use that against me as a wrongful termination. Okay, so if you're put on a performance improvement plan and then terminated at the end of it, a lot of employers try to do that to justify a with cause termination. And it's not that easy to use a performance plan to get to the point where with cause termination is allowed. So, depending on what's in that performance plan, what the areas of performance are that had to be improved, whether they're outlined clearly, whether you are receiving help to achieve them, whether you were told how long you had to achieve those, given clear parameters on how, why, when, and told that if you don't get there, that you're going to be terminated. It is difficult for an employer to successfully implement a performance improvement plan to get to a termination. So if there is a termination after being on a performance improvement plan and they're saying it's a just cause termination, I would definitely reach out to us to try to determine where or how much severance that we can try to get for you, because there should be entitlements there. From what I've seen in the past, when employees are put on performance improvement plans, it's rare that the employer does them properly enough to get a really good case of just cause for dismissal. It's often that's what they're trying to do, and it's all quite fake. So if you go on the performance improvement plan and they do a termination and they offer severance, they offer some amount of severance, then you have to look at how much is appropriate and are they giving you an appropriate offer. So and the way to do that is to use initially anyway our severance calculator, which is online, and I believe that's a pocket employment lawyer tool that we offer. And if you go in there and give us a little bit of information, it's all very general. It's nothing personal. It's just kind of things like years of service in your position. It can tell you what your proper severance amount might be. And then you'll know if you did get that offer, whether or not you're getting a good offer or whether you need to talk to somebody about it. So we have another question coming in from Facebook. It says, can the employer ask an employee to resign when they're on medical leave? Not legally. A resignation by an employee must be clear and unequivocal and has to be your own decision. So you can't, nobody can make you resign. So if your employer asks you to resign and you don't want to, just don't resign, because if you do resign, then you're not entitled to any severance. So the employer should not be asking you that while you're on medical leave for a number of reasons. First of all, under employment standards, even there is a 16-week job protected medical leave that says that they have to bring you back after 16 weeks. So you have a full 16 weeks of being on medical leave before they can even think about terminating you without cause. So asking you to resign while you're on medical leave it would be a violation of the code. Again, there's human rights elements in there. If they're asking you to resign because you're on medical leave, then you're being discriminated against because of likely a disability. That's assuming that you're on medical leave for a reason that relates to a disability. And disability is pretty broadly defined, can be any kind of mental health diagnosis like anxiety or any kind of physical ailment that's sort of not just really transitory. So anything lasting for kind of a significant amount of time is a disability. So you don't have to resign, I guess, is the bottom line on that. If the employer asks you, they should not be asking you. And it does not make sense to agree to that at all. So I think that's a situation where, if that gets pushed on you and they eventually, try to push you to resign or take the position that you've resigned, then you're going to need to look into what severance you can claim and reach out to us for sure. Another question from Joe. My employer just let me go. I work for a call center based in the US. I am in Canada. They said they don't pay severance because we are at will. Is this accurate? No, it's not actually. There is no such thing as at will employment in Canada. That is an American concept. If you are located in Canada, you should be subject to Alberta or whatever Canadian employment standards, depending on which province you're in. So no, they cannot really do that. You may have some sort of employment contract with them that says that there's a choice of laws and that you've decided that you're governed by the law in some state, but that doesn't get rid of the actual employment standards legislation that protects Alberta employees. So if you are physically located in Alberta, you are subject to, or you're protected by Alberta employment standards, and there is no such thing as at will employment in Canada, really. So no is I guess the short answer. Another question from Corey. I worked for 20 years. How much notice am I owed from my employer? So it depends on a lot of other factors. Years of service is definitely an important one. But what I would suggest is that you do go online and use that pocket employment lawyer. It's our severance calculator. It will ask a few more questions other than just your years of service. Some of the more important factors to how much severance that you're owed are years of service, yes. Age is a factor. Employees over the age of 50 are generally thought to have a harder time finding replacement employment. So severance packages may be longer. If you're 35 or younger, might make it a bit shorter because young employees are generally thought to be able to find employment quicker. Your level of position is another one, and the availability of similar employment. So, if you're in an industry or in a job where it's really easy to get reemployed, there's lots of jobs for what you do, your notice period may be a bit shorter. If you're in a situation where your job is really specialized and there's really not very many of those jobs, it may be longer. So, a lot of people come to me and they kind of assume it's like 1 month per year of service. It's not necessarily true. It could be more, it could be less. So I would suggest, try out that pocket employment lawyer calculator and see what that comes up with. And that should give you a rough idea of the answer to that question. And if you need more information, always reach out to us. I have a question from Sam that says, hello, is ML a good abbreviation for mainland United States? I don't know the answer to that question. So I'm going to go to the next one. Next one is from Ermail, and is severance different from settlement? Okay, so yes, but I mean, you can get a settlement for your severance entitlement. So severance entitlements basically mean what you're owed by your employer when you're terminated. A termination, a wrongful dismissal is basically just your job being terminated without being provided with proper severance, right? So when you're terminated, they should provide you with that proper severance. If they don't, then you come talk to us, or try to negotiate that amount. And what happens with settlement is when both sides agree to a number. And that's a settlement, right? So severance entitlement is what you're trying to negotiate. And when a settlement is more like the agreement on how much that's going to be. So sometimes with settlement, say our calculator comes out to, it says, you're entitled to a year of severance. Sometimes a settlement might involve a compromise on both ends. So it's like a compromise, and it just gets everybody to a point where, we've decided that this number works for us, and everybody walks away happy. So they are slightly different concepts, but you can get a settlement for your severance. Hopefully that helps. Another one is a question on YouTube. This one's from Edward. I was just let go from my job without cause after 12 years for unexplained reasons. The employer is only offering a piddly 8 weeks termination pay or less than $3,000. According to the severance calculator, it says I should be between $33,000 and $44,000. How can an employer offer such a drastically smaller amount like that? So if you've been at your job for 12 years, your 8 weeks is the minimum under the Employment Standards Code. So what the employer is offering is your statutory entitlement, meaning they have to, that's not an offer, they have to pay that. What would be offered above that is your offer of additional severance. Many employers will try to get away with just paying what the Employment Standards Code requires, that minimum amount. But under the common law, as we call it, that's where that $33,000 to $44,000 comes in. And I mean, it happens. I mean, how can they do this? Well, they do. They're trying to save money. And that's why we're here to protect your rights from employers that do try to lowball you and try to just get away with paying the minimum statutory entitlements, when really under the law, your entitlements are much higher. One thing I would suggest in this situation, though, is that there is the ability between an employer and an employee to sign an employment contract that may restrict your rights on termination. If you have some language in an employment contract that says you only get what is payable under employment standards, it may be possible that that's all you're going to be owed. However, that language has to be very, very well drafted. There's lots of things that can go wrong with that kind of language. So if you do have that kind of language in your employment contract, I would very, very much recommend that you have it reviewed by one of us at Samfiru Tumarkin, because what we can do is we can look at it and we can find out whether or not that clause is going to be enforceable by a court. I'd say at least 50% of the time, the clauses are not enforceable. They're not drafted well enough. So, if you do look at your contract and you go, oh no, I signed something that said I'm only going to get employment standards minimums, which is the 8 weeks, don't stop there. Get us to look at it, because that language might not be enforceable. But in general, you are owed more than that employment standards minimum, which is what they're offering, the 8 weeks. So hopefully that answers your question for you. I think we have Joe again he's employed by the US employer, and he's saying, is it difficult trying to get severance from an employer in the US? Does it take longer if they're in a different country? I mean, it could. A lot of US employers have Canadian counsel or Canadian lawyers that we talk to. I've dealt with a lot of even Calgary companies that are based in the US. So we have to deal with US counsel. It becomes a little bit sometimes of trying to educate them on Canadian law. And once we get them there, we do get settlements with US companies, and we are able to get people their severance. Once they understand that no, at-will employment is not a thing when your employees reside in Canada. So it may take longer. It may be difficult, but it also may not be. There's really no one way that things play out when we're trying to negotiate severance packages. And I have had a lot of success talking to US lawyers. Once the company engages counsel, if they are employment counsel and they have dealt with Canada before, they may quickly realize that what the employer has done is not legal. And if they don't, then that's where we come in and we educate the US lawyers on what the law is in Canada. And, it's not that hard. We send them our legislation, we send them some case law, and they learn pretty quick. So I wouldn't give up just because you have a US based employer. We have matters all the time with US based employers. So I have another question. It's coming in from Reddit, and this is from Danny. Sounds like an employer side question. I have an employee currently on maternity leave. She's set to return in a month or so, but I no longer have a position for her due to downsizing and restructuring. What can I do in this situation? Okay, so when an employee comes back from maternity leave, you are supposed to put them back into an equivalent position, either the same position or an equivalent position. You could be in a position where you are in violation of the Employment Standards Code because they are protected when they go on maternity leave. If the position has been eliminated legitimately, there is an exception in the Employment Standards Code dealing with that, but it's not a get out of jail free card. You will need to deal with that employee and, take into consideration also human rights issues. You can offer them a severance package. It all comes down to, can you get the employee to agree to be severanced out? I think likely there's a bit more risk here as far as how much that employee is going to be entitled to, because there's likely, some human rights problems. Why is this employee not being brought back? Well, it's because she was on maternity leave, and while she was gone, her position got eliminated. So there's risk there when it comes to human rights damages, which can be more than severance. So, I would say be really careful with that. That's a situation. If I was an employer, I would definitely want to make sure that I've got good legal advice. I'd like to know, some more of the specific details on this. As to why the position's been eliminated, how long she was there before that, what your exposure is, because it's going to depend on. It's going to depend on a lot of things as far as, what can be done and what your risk is and what the best steps to take are. So I would say, get some legal advice on that, reach out to us and we can help you. We do represent mostly employees, but I would say I have, probably 20 or so employer clients that I give advice to on a regular basis as well. So we do represent employers as well, and we do give legal advice to employers. So you can find us on our website, and hopefully we can help out. So I think that's all the time we have. That went super fast. So thanks to everybody for sending their questions in. There's a lot of good questions, and I hope it was a good discussion, and I hope I provided some information, and if you need to follow up, you know where to find us. Next Employment Law Live Q&A is this Friday on October 25th with one of our lawyers I believe he's out of the Toronto office. So hope to see you all there, and have a good day. Thanks.